New York, New York. Skyscrapers soar and fraudulent enterprises crumble. Week 2 of the New York Attorney General's civil fraud case, and it was devastating against Donald Trump as the Trump Organization insiders like former CFO Allen Weisselberg and others testified during trial. Not only did we see smoking gun after smoking gun evidence laid out in court by the New York Attorney General's office, but the testimony by Trump's former CFO, Allen Weisselberg, who has a very suspicious severance agreement, was abruptly halted when it revealed during the testimony serious criminal exposure for him and Donald Trump. We will discuss. Never a good thing when civil cases become criminal cases very quickly. Next, we compare 2 federal criminal cases against Donald Trump being prosecuted by Special Counsel Jack Smith. One in Washington, D.C. for Donald Trump's attempt to overthrow the 2020 election, and the other in the Southern District of Florida before Judge Eileen Cannon for Trump's willful retention of classified documents and other national defense information. It's a tale of 2 judges, isn't it? In Washington, D.C., federal judge Tanya Chutkan runs a tight ship, and important motions were filed this week by both Smith and Trump's teams. On the other hand, Judge Eileen Cannon threw a temper tantrum, blew up a hearing over potential conflicts of interest involving Donald Trump's lawyers, called the Garcia hearing, while it was taking place in court because she said that she got upset with Special Counsel Jack Smith's team, and so she yelled at them, and she stopped the hearing and said, "Go away, shoo," and she postponed it indefinitely. She's really making a fool out of herself and our judiciary. Next, we go to Georgia, Fulton County, where this month we start the first criminal RICO case against Donald Trump's co-defendants. 2 of them, Ken Chesbrough and Sidney Powell, who tried to call District Attorney Fani Willis's bluff, and they demanded a speedy trial. But it don't seem they want it to be all that speedy anymore. Rule number 1 of RICO Fight Club: don't call Fani Willis's bluff, and they're learning that right now. She's ready. Judge McAfee is also ready. And Fani Willis is so ready, she doesn't have time for that MAGA mosquito, Jim Jordan, trying to interfere with her case. Get away, Jim. And from MAGA mosquito to MAGA mosquito excrement, Rudy Giuliani. Not only did a federal judge in the defamation case filed against Giuliani by Georgia election workers Freeman and Moss find that Rudy was liable for defamation, the federal judge just ruled that based on all of the discovery abuses engaged in by Rudy Giuliani during litigation and his clear attempts to cover up his financial condition. Oh, another MAGA covering up their financial condition. The jury is now permitted to make an adverse inference in assessing damages, and specifically punitive damages, that Rudy Giuliani intentionally concealed and hid his assets to try to avoid the jury from knowing his true net worth. I'm Ben Meiselas. This is the LegalAF podcast. Michael Popok, the wheels of justice turn and they churn and they move in the right direction. How are you doing, sir? Michael Popok, how you doing, sir?
Oh, we're playing Ben and Popok pop culture bingo, and you had Fight Club, New York, New York, Tale of Two Cities. I'll add Mosquito Coast and Rudy. You just won bingo based on Ben's opening. Ben, I love the pop culture references and tying it all together today. 2 observations before we jump all into it. I want to answer a question that often gets asked. Mar-a-Lago is not a complicated case. It does not take more than the time allotted from now until May to try. New York fraud case is not a complicated case. Donald Trump does not do complicated things. You can make your own assumptions as to why. You could try 2 Mar-a-Lago cases in the time that's left on the clock between now and May. You could try 2 New York fraud cases in the time that they've had. Hiding documents from the government and using half a dozen people to do it is not a complicated case. Changing your numbers and just artificially inflating them and adding 20% or 30% onto your net worth in order to defraud insurance companies and banks and using half a dozen people to do it is not a complicated case. Donald Trump does not warrant long trials or long preparation sessions, no matter what his lawyers say in all of these cases. There's no reason for any delay, and these cases should go off on schedule, just as scheduled in March and May and whenever we get to Phony Willis's case in Georgia.
I agree with you. You know, the one, if you want to say which one of all of them is the most complicated, the RICO criminal conspiracy in Fulton County, Georgia, where the judge is handling it perfectly, ably, steady, and also the case in Washington, D.C. before Judge Tanya Chutkin, right, where Judge Chutkin handling the case perfectly, moving the case along. And it's not like she's special counsel Jack Smith, whatever you want, file in my court and you'll get expedited briefing. She's even. Both sides, they file things. She moves the case along. And you can see that the litigants respect her for doing that. That's what you want in a judge, someone who conjures respect. And let's be real, though, like with Judge Cannon, you have Donald Trump and his motions in the Southern District of Florida treating her like she's a buddy. You can see it in the filings that there's the wink and the nod right there. Like, we need you to do this for us. It doesn't say it so expressly, but that's what's going on. And then you have her at these hearings that shouldn't be complex hearings, and we'll talk about it later in the show. But you have a conflicts of interest hearing over Donald Trump's lawyers and whether the lawyers being paid for by political action committees who are also representing other co-defendants and who are representing witnesses, whether there's these conflicts of interest that are unwaivable or that there should be some other remedy. But like, you got to go through with the hearing. And I get that judges could be mad at litigants and may just assume for the sake of argument that Judge Cannon was validly upset at Jack Smith's team, which I don't believe. Hold the hearing, get the evidence out, and then if you think there's a sanction or something you want to do once the hearing is completed, then you do it. It's like you don't start the sports game. You don't like the way it's going. So in the first inning of a baseball game, you go, you know what? Let's not do these 9 innings. I don't want to do it. I'm upset. You go through the process and then you let the chips fall where they are. But we'll talk about that later in the show. But let's go to New York, New York. This was week 2 of the New York Attorney General civil fraud case against Donald Trump. And just because Trump isn't there, it only lasted 2.5 days of ranting and raving like a lunatic. The first week of trial where a gag order was imposed. I know the media loves that. And then they move their attention elsewhere. But it's important that we focus on what's happening with the evidence on a weekly basis so that false narratives are not created and that we follow the evidence wherever that leads. We follow the evidence. So this week, we had testimony again from Donald Trump's former CFO, Alan Weisselberg, some bombshell testimony there about his severance agreement and the amount of his severance agreement matching the criminal fine in his criminal plea agreement and whether that constitutes obstruction of justice. Potential perjury of Alan Weisselberg on the stand when it became clear that he was not being forthcoming and then outright lying about his involvement in calculating the properties. And some Forbes reporters got the documents and data and emails to back it up that they went to the New York Attorney General's with. You had an ex-risk manager at Deutsche Bank testify, someone named Nicholas Hague, who kind of rebutted all of these kind of Donald Trump talking points, that the bank just blindly accepted whatever Donald Trump's, statements were, and that the bank was relying a lot on these statements made by Donald Trump. There was a due diligence process, and where fraud was being committed, that could change their determination about whether they would have made a loan or not. And then you had the testimony from a current Trump Organization person, Patrick Burney, who went through the fact that Alan Weisselberg, who claims he wasn't involved in a lot of things, would provide these notations that presumably came directly from Donald Trump, but these notations on statement of financial conditions that talked about adding brand premiums from 10, 15 up to 30% brand premiums that were based on Donald Trump claiming, former president residence or presidential residence, add a brand premium. Add the brand premium for the fact that it's Donald Trump lives there. And Donald Trump saying, my brands were never added into brand premiums were never added. They were. There are notations. There's evidence that backs that up. So evidence. Popok, what did you think about week 2?
I liked week 2 a lot. And what we're seeing, let me take the plane up 20,000 feet. What we're seeing is a masterful presentation of evidence over a trial that's going to last up to 100 trial days. This is only the first 2 weeks. We're going to talk later in this segment about the order of witnesses or who's going to be coming up next. And what I like so far is this nice momentum that's being built in the narrative in front of the trial judge, no jury, of insider witness, outsider witness, insider witness, outsider witness, insider witness no longer with the company, outsider witness no longer with the company. None of them, all of them kind of different pages in the hymnal that's being presented of the fraud. So you start in week 1 with the ultimate outsider in Don Bender, the 12-year-long accountant auditor for everybody related to Trump, including personally, who knows where all the bodies are buried, and pointed the finger at the Trump Organization, Donald Trump, Alan Weisselberg, and McConney, the controller, for fraud. That they misled the auditors, they did not provide proper information, and focusing in on Trump Tower. We spent a lot of time talking about the Trump penthouse and why it's only 10,999 feet and not 30,000 feet, not because it's an ego thing. It's because there is criminal, or in this case, fraudulent conduct that started in 2017 and that Michael Cohen will testify to and the others have testified to, when Forbes magazine, which you already mentioned, got the floor plans from the fire marshal and the building department and the Department of Buildings in New York, and figured out very quickly that the apartment on 3 levels is only less than 11,000 square feet. And that created once they outed Donald Trump on the size of his apartment, that created a hole in his balance sheet of a substantial amount that had to be made up some other way. Now, normally, when you have a hole in your balance sheet, you want to increase the value of it. You go buy and you acquire more assets, not Donald Trump. Donald Trump gave the instruction to keep the existing assets and just inflate them artificially by making up numbers, putting premiums on them, a 20% presidential premium, a 30% ex-presidential premium. This is when I say premium just here, I just made up a number. It'd be like you taking your own personal balance sheet. Let's say you've got $1,000 in the bank. You just add 30% on and you tell somebody that you have $1,300 in the bank. You only have 1,000. But you've added a 30% premium. Now, do that to Donald Trump with a lot more zeros, and you get the sense of what's happened here. Michael Cohen will come in and support that. So insiders, the first 2, the money men, 30-year, 50-year plus organizational money men in McConney, the controller who reported to Weisselberg, the disgraced felon chief financial officer, who doesn't understand what generally accepted accounting principles are, that he testified. I don't know how you can be in a control position within a company that's got money flowing through it if you don't understand that. More importantly, during the testimony of Alan Weisselberg, the reason that the attorney general calling this hostile witness, which is what Alan Weisselberg and even McConney are, because they're on the other side of the V. They're defendants. But she's swinging for the fences here, and she's doing a masterful job, the Attorney General, in bringing in these adverse witnesses, but knowing that she has their testimony from the New York Manhattan District Attorney's tax evasion case that went terribly for the Trump organization last year, with 17 felony counts, conviction by a jury against the Trump organization and all of its entities, and Alan Weisselberg particularly 17 felony counts, and he went to jail for it. So they had the testimony from that. McConney had testified in the tax case under an immunity deal with the Manhattan TA. So he's the most honest of all of them. But they were ready for Weisselberg. And Weisselberg did not perform the way he was expected to on that stand. But they were ready that he would try to not remember things, which is what he started doing. I don't remember that. I don't recall that. I don't remember that. I don't remember that. He had to admit to things that were in writing, like, isn't that Donald Trump's signature on the bottom of a representation to banks that he would not include brand value and brand percentage as part of his balance sheet, as part of his net worth? Yeah, that's his signature. He had to do that. But in the places where he wasn't being cooperative, and to signal to the judge that there's a credibility problem here, when this witness that you want to track suddenly goes off the track, then you have to punish them. And the way that you punish them is the way the New York Attorney General did, which is, let's talk about your separation agreement with the Trump organization. They committed to paying you $2 million, didn't they? Yes. And that's the same $2 million number as you have to pay or paid in a fine related to your tax evasion conviction, right, sir? Yes. Coincidence? I would say it's a coincidence. Okay. And let's go through the payment schedule. You've gotten you've gotten $750,000 in payments, but you're owed $1.2 million left, right, sir? Right. And it says here you can't voluntarily cooperate with anybody. It has to be by subpoena, right, sir? And if you violate this agreement, you're not going to get your money, are you? The only reason that came out that way with a witness that they called is because Weisselberg wasn't playing ball. And he was not giving them what they wanted. Now, they don't need Weisselberg to nail Donald Trump in this fraud case. That would have been icing on top of icing on the cake. But when he started effing with the cross-examiner for the New York Attorney General, that's when they decided they needed to punish him and bring that out. Fortunately, you're in front of a judge, and the judge is always evaluating credibility of witnesses. And so that was a signal to the judge. He's saying some things that we think he remembers. He says he doesn't remember, but I want you to know, Judge, why he may be doing that. And that's why that thing came up. The only witness so far that currently works for the Trump organization, everybody else either getting severance payments or waiting on them, is Patrick Burney, this poor guy. He's been there for 9 years. He's an assistant vice president. Donald Trump testified in his deposition. He didn't know who the guy was. I don't know any of these people personally. I really don't know who that person is. He's going to go on. He went on the stand and basically said, Trump through Weisselberg and McConney made me do it. They made me add 30% values onto numbers and add $20 million onto the value of the Trump Tower building for no good reason. And so he's just going through, and they interviewed him and they know what he's going to say. And he's just going through all of that. Next week, they're going to bring up another employee who's a assistant controller that reports to Weisselberg. And I assume based on the debriefing in her interview, she's going to be very supportive of the fraud case. I love, though, Ben, the inside outside of witnesses and the momentum that they're building through the first 2 weeks of a trial that's going to go on for 3 to 5 months. And I don't really care if Donald Trump shows up or doesn't show up. It's all a distraction. It's, as I said on a hot take, it's the circus comes to town. It brings the giant elephant. The giant elephant craps over everything, and then you got to clean up behind him, and he leaves. That's what's going to happen. It'll have no impact on the witnesses that are testifying. He already said he doesn't know most of the witnesses for the Trump organization who are testifying, and the only thing we're waiting on that I'm sure you have your opinion about is when Michael Cohen finally testifies, and if Alina Habba is the one that's going to cross-examine him. I mean, that's where I buy my popcorn.
It'll be interesting to see if Alina Habba does the cross of Michael Cohen. Michael Cohen has requested, based on health conditions, that his testimony not take place next week, but I'm sure it will be taking place within the next few weeks, and we all wish Michael Cohen well. Alina Habba took his deposition, and so will she do the cross-examination? I'm interested in a point that you made, Popok, which I'll touch upon before moving to the federal criminal cases, is Alan Weisselberg, when he was there as a witness, brought upon himself the fury of the cross-examiner by saying, I don't remember, I don't remember, I don't recall, and trying to play that game. Because of that behavior, the cross-examiner, the lawyer who's doing a great job from the New York Attorney General's office, grilled Weisselberg on his severance agreement, as you mentioned. Now, the criminal penalty for Weisselberg when he took the plea agreement in the Manhattan District Attorney criminal case for the fraudulent tax benefits he received. Remember, he served time on Rikers Island. In addition to the sentence that he had for incarceration, he had to pay a $2 million fine. The severance agreement was for $2 million. If there was a quid pro quo payment by the organization to pay him off and to hide that as severance for compliance with what Trump and the organization wanted him to do in that case and in other criminal investigations, that is classic, textbook obstruction of justice crimes. Now, if Weisselberg just basically, instead of going, I don't recall, was forthcoming and he acknowledged the existence of a severance agreement and just answered the questions, the New York Attorney General lawyer would not have spent the focus proving very credibly that another crime was convicted. Right? Weisselberg looked like he was guilty, and Trump did as well, of obstruction of justice. And guess who's watching this other than us here at the Midas Mighty and LegalAF and the rest of the country? But clearly, the Manhattan District Attorney's Office is watching. They're waiting. It's still within the statute of limitations to charge Donald Trump or to charge Weisselberg or some of these other people again. And I predict that they are going to do that after there is a final resolution or close to it in this civil case. I think it will lead to more criminal cases and more exposure. That's why Manhattan District Attorney Alvin Bragg, I think, strategically was waiting. He brought the case involving Trump's unlawful characterization of the payment to Stormy Daniels as the first case, but he didn't waive his right to bring a future criminal case. So I want everybody to watch for that. And then Weisselberg seems to have committed perjury on the stand, another crime. One of the reasons his testimony abruptly ended, as well as the Forbes writers said, wait a minute, Weisselberg is saying that he had no involvement with the triplex and that he doesn't remember having these detailed discussions with us.
Triplex.
See, well, there is a raging debate about that.
Not in New York.
I'll
and
leave
Goron corrected the witness 3 times when he said triplex. It's triplex in New York.
All right. We'll see. we will see. So we've got that going on in New York, and then and with respect to Forbes, the Forbes writers reached out to the New York Attorney General's office and said, hey, look, we've got all of the evidence right here. Let's talk about what's going on in the federal case in Washington, D.C. and in the Southern District of Florida, both being prosecuted by Special Counsel Jack Smith. The D.C. crimes against Trump relate to his attempt to overthrow the 2020 election. The Southern District of Florida crimes relate to Trump's willful retention of national defense information, obstruction of justice, making false statements. His co-defendants in the Southern District of Florida case include Walty Nauta, his valet and personal assistant, as well as Carlos de Oliveira, a maintenance worker who works at Lago and is still employed at Lago, apparently. Okay, so in Washington, D.C., a number of motions were filed both by Special Counsel Jack Smith's team as well as by Donald Trump. Special Counsel Jack Smith's team, these were all opposed by Donald Trump. Jack Smith wanted to bring a questionnaire or lodge a questionnaire to be sent out to the jury, a written questionnaire in advance of trial so that they could start the jury selection process early and promptly, so there's no delay. And Jack Smith also wanted to protect the identities of jurors receiving the questionnaire from public disclosure. We're not talking about an anonymous jury yet. That request hasn't been made. It's just prohibiting the public disclosure of jurors who receive this potential questionnaire. Donald Trump opposed that. One of the other things Jack Smith requested is that there be a requirement that Donald Trump determine or make clear if he's going to be asserting an advice of counsel defense, because that has implications on the waiver of attorney-client privilege. And Jack Smith wants to get ahead of Donald Trump playing games where once trial arrives in March, then Donald Trump goes, oh, now I'm blaming my lawyers. And then it becomes more difficult to deal with the waiver of attorney-client privilege that would trigger, because you then have to then release all of these documents which are currently being withheld under attorney-client privilege. So Jack Smith's like, look, I want these attorney-client privilege documents now if Donald Trump's going to assert advice of counsel, because that's a consequence of asserting advice of counsel as a defense. So those are on the Jack Smith side. Want to hear your thoughts on that, Popok. But then on the Trump side, Trump filed a motion to issue various subpoenas that are part of these deranged conspiracies that are being spread about, saying that the January 6th committee deleted evidence, which is totally false. I want you to talk about that. And then Jack Smith's lawyers filed a motion requesting attorneys' eyes only access to SEPA Section 4 documents. There are classified documents in the DC case as well as the Southern District of Florida. And Trump's lawyers wanted to get access to the Section 4 documents. These are documents that were submitted by the prosecutor to Judge Chutkan for her to allow a summary of the documents, because they're so sensitive. They don't want to turn them over to the criminal defendant, in this case, Donald Trump. SEPA Section 4 provides a process for that. And Trump's lawyers are saying, Judge, you have discretion. We've been good, haven't we? We've been good lawyers. We've been nice to you. We've treated you with respect. Can't we get attorney's eyes access to that for now so we can be involved in the process? And of course, I'm being a little bit facetious there when the lawyers are saying, hey, we've been good. These are the lawyers who are claiming Donald Trump's threats against witnesses, against the judge. The judge has received death threats. These lawyers have said that's perfectly acceptable speech before. So a lot of motions, but Popok, Judge Chutkan is moving her docket along, and she said expedited briefings for all of these motions. She's not going to have any delay in her court. But I wanted to give the framework of the various motions, because it's a lot, and then get you to really bring us into the weeds and what's going on here.
Whenever I hear Judge Chutkan, when I do a hot take, I automatically put in it so it doesn't go stale that she will set a very fast briefing schedule and get to this issue right away. And especially whenever Jack Smith's team does it, she wants to bring these issues to a head very, very quickly. She has a very strong executive function in her brain, unlike Judge Cannon. She makes decisions very quickly and efficiently that matter to keep her case ultimately on track for a March 2024 date to pick a jury that's on the minds of Jack Smith already, which it should be. You and I speculated a week ago about how, or so, maybe it was a week and a half ago, how would or if the federal prosecutors would bring to the attention of Judge Chutkan that Donald Trump was at it again, and in week one of the trial, this fraud trial, had attacked in social media Judge Engoron's principal law clerk as staff, and got a gag order placed against him in real time by Judge Engoron as a result. And they found a way to slip it in. They slipped it in not as a supplemental to the gag order that Judge Chutkan, is considering and having a hearing this coming week over, about whether on the issue of jury involvement, Donald Trump should be limited and go through the court system about how he's going to do interviews and a mock jury process, and also to stop him from continuing to attack witnesses, staff, family, and prosecutors. They left off the judge, but I think they would also like him to stop bashing Judge Chutkan. I think Trump should want to stop bashing Judge Chutkan, because whatever he thinks it's doing in terms of inside the courtroom, it's not. It's having the opposite effect. I think it's just concentrating the minds of everyone that's a professional to just do their job and leave no stone unturned. And that's what we're seeing with Judge Chutkan. So they slipped it in with the reference when they asked for a jury questionnaire and that the jury be anonymous. Now, Donald Trump is no stranger to anonymizing a jury. It happened to him, whether he wanted to or not, in the civil case in New York with Judge Kaplan in the E. Jean Carroll rape and defamation case. It happened again to him just a week or so ago with Judge McAfee, who in a very one-page order granted Fani Willis's request that the jury be anonymous. And having seen what happened to the grand jury, whose names were released per Georgia law, and then everybody in Trump's world having bashed them, doxed them, posted where they live and the coordinates of their work addresses, the judge was like, yeah, where do I sign? So now we've got a third judge that's going to have to consider and making the jury anonymous. And I gave the Jack Smith's team a lot of credit, because in a footnote in that motion, they actually said, not only are there appropriate grounds based on his recent behavior, and pointed to New York and the doxing of that poor law clerk, again, Judge, but we think there's appropriate grounds to even go as far as sequester the jury. I mean, that's the S word you rarely hear anymore, especially in a case like this. But they've actually said, we think there's enough grounds for sequestration, meaning putting the jury up in a hotel for the next 4 to 5 months, not letting them see their loved ones, nor connect to the world through social media or otherwise. And their new best friend is a federal marshal, taking them in and out of the room into the courthouse and back. Nobody wants that. That does not make for a happy jury, either for the prosecution or the defense. But the fact that they even kind of put that out there, to then have the judge walk it back and say, we're not going to do the sequestration thing, but I am going to do the anonymous thing. And I think that's where they're trying to get the judge to end up. On the advice of counsel issue, they're just calling out Donald Trump and his lawyers for all their BS that they've been running on right-wing social media and in interviews. Every time they get the chance, last month's talking points to end September was, Donald Trump took advice of counsel. He had very competent counsel, constitutional counsel. He just listened to his counsel. Now, may I remind everybody on this podcast that almost every one of that quote unquote counsel are his indicted co-conspirators in Georgia, at least, and unnamed co-conspirators in Jack Smith's case. I don't think relying on the guy that's also, potentially going to wear stripes with you in jail is going to give you a defense. But because that defense is out there, which is it's a judge-made defense. It's what we call in trial practice an affirmative defense. It's not found in the federal rules of criminal procedure. You're not going to find a chapter or a section on advice of counsel, but the precedent of case law has developed it. But it's up to the judge to allow it if she thinks the facts support it, and then give the jury an instruction over it. And so it's very serious, and there's a gatekeeping function for the judge to keep out bullshit, pardon my French, attempts to assert this, because it'll just confuse the jury if there's really no evidence to apply it. It could lead a Trumper on the panel to go, advice of counsel, you got a lot of lawyers around. Where do I check the box for a hung jury? We don't want that to happen. And then it's having an impact on the discovery, meaning the subpoena process, the obtaining of documents, testimony, and information, because Jack Smith's team is getting hit by at least 25. They've identified 25 subpoenaed parties, including somebody related to Donald Trump. If I had to guess, Jared Kushner. I don't think it's Ivanka. Jared Kushner, who's saying Donald Trump is asserting his attorney-client privilege. I can't produce those documents to you. Well, if he's taking the advice of counsel affirmative defense, he's effectively waived his attorney-client privilege. There are no documents with these people that wouldn't end up in the hands of the prosecutor to be used at trial, and they want to know now in October, not in March or April. They want to know now whether he is going to try to assert that privilege and let the judge decide the issue. And then that has the ripple effect through the discovery process, because if he says yes and she says okay, you can try it, and then the waiver happens and they get all the documents and testimony that they want. Pardon me. So they're trying to bring all of that up. And then there's nobody on this network that knows SEPA better than my co-anchor, Ben Meiselas. I'll let you do the SEPA part, the ins and outs of that, before we move on to what's going on with Judge Cannon.
Yeah, I mean, SEPA Section 4, as I mentioned before, has a portion where if there are super sensitive documents within the classified documents themselves. Because remember, there's what's under the Due Process Clause of the Constitution, under the Sixth Amendment of the Constitution. There are all these rights that criminal defendants have, and we want criminal defendants to have these rights. And one of those rights is you get the documents, you get the discovery against you. There's something called a Brady right, where you get, which is based on a case where you get exculpatory information. The government has to make that available to you as well. When it comes to classified documents, that's layered on the discovery obligations as well. And there's something called SEPA, Classified Information Procedures Act, where you're dealing with classified information that has to be turned over in a case. However, there could be some documents that pose such a national security risk that you have to balance the defendant's discovery rights, obligations, due process rights with our national security interests. Like, do you turn over the nuclear secrets that the criminal defendant was trying to steal to the criminal defendant in a case? Does that make sense? And I'm giving that as just a hypothetical example. And that's probably some of the issues that are being grappled with in the Southern District of Florida case. But there clearly are very sensitive documents as well that Special Counsel Jack Smith wants to avail himself of this very specialized procedure in SEPA, Classified Information Procedures Act, Section 4, that deals with providing the document through a special procedure to the judge alone. The judge can then allow that to be removed from the government's discovery obligations, but a summary of the document or some other means of transmitting the info, but not showing the highly sensitive document to the defendant, that takes place. And Trump's lawyers are asking for access to perhaps even challenge the SEPA 4 Section 4 designation of these records. And they want access. They're like, well, Judge, we think that Donald Trump should be able to see it. But even if Trump can't see it, trust us as the attorneys. We'll do what's called attorney's eyes only review. And we won't tell Donald Trump what we look at, but we want you to exercise your discretion, Judge. Do us a solid and let us look at the documents as well, so we can assess the claim here about SEPA Section 4. So that's being briefed now. And ultimately, as I said before, it's like on Monday, there's going to be a hearing on October 16th over Donald Trump's threats against the judge, against witnesses, against all these people, where these same lawyers who are asking the judge to exercise her discretion because they're trustworthy people, they're submitting briefs saying that Donald Trump's threats, where he's threatening to execute a witness, the former top general of the United States, Mark Milley, where they're saying Donald Trump's behavior, they're telling the judge in their briefs that that's good, that's acceptable, normal behavior that litigants should engage in. So when the judge is trying to balance our national security interests and lawyers are saying, hey, just trust us, Judge, it'll be attorney's eyes only, they don't exactly come off as fair arbiters and members of the bar acting in good faith. But that will be briefed. We'll see what happens there. And as I mentioned, of course, there's that big hearing on Monday where probably one of the biggest hearings yet on the gag order over Donald Trump's threats. And I'm very curious to see how that hearing.
I want to ask you a question too when you're done. Sorry.
Tell me about it.
About gags. I'm of two minds. I want him to stop. There's a big part of me that's like, put him in. I want him to stop, gag him, and let's talk about the repercussions of that. Then you got to find him in contempt, and then a judge has to have the brass ones to put the person in jail. Okay, I'd love that. I also love when Donald Trump talks without any restraint and has bad things happen to him and generates and creates new evidence. because that also helps the case. As prosecutors like to say, you keep developing the evidence in your case and investigating right up until trial, because you could find really good things there late in the game. Where are you on the spectrum? Gag him, contempt, and try to put him in jail as a candidate for office, given his bad conduct, or let him talk?
Treat him like everybody else.
Mm-hmm.
That's where I stand on it. There is no favor that should be afforded him. There should be no different treatment. If his conduct is the type of conduct that would result in any litigant being remanded to jail, remand him to jail, and you show that nobody is above the law. You know, one of the things with Donald Trump is that he's a very weak person who gets away with things because people mistake his bloviating behavior as strength. And it absolutely isn't. When he is, and by the way, our enemies know that. Authoritarians know how weak he is, and they know exactly how to prey on that. Heck, all you got to do is call him sir, sir, and he goes, they called me sir. They called me sir. He's as weak as you can be. So you have to confront a weak wannabe authoritarian like that who violates our law with the full force of our law. No favor at all, no difference. There is a massive body of evidence against him, and I'm not worried about whether they'll be more or less developed. He shouldn't be allowed to threaten anybody. He shouldn't be allowed to behave like that. I always see in our comments, I see when people speak to me when I'm walking on the street, one of the things that people are upset is about, why isn't he being held accountable for his conduct and the conduct within the litigation? If you don't hold someone like that accountable, it creates a view that prevails that our laws and our rules and our norms don't apply to him. So, you know, to me, I'm with you. Do I like that there's more evidence developed? I mean, you know, sure. But ultimately, you got to hold him fully accountable. I want to talk about Judge Cannon, what's going on in the Southern District of Florida. Want to hear about what's going on in Georgia. We're gearing up to have a trial that is going to be broadcast on our YouTube channel of Trump's co-defendants in the next 10 days. Think about that, Popok. And then we got to talk about who I refer to as MAGA mosquito excrement, Rudy Giuliani, and what Judge Beryl Howell just ruled there. We'll talk about all of that after this quick break.
I'm from a family that loves to cook. In fact, I have a working theory that my wife married me because I know my way around a kitchen and cook with a generous hand. But with any good, healthy cooking comes the really hard part. Clean up in an environmentally friendly way while trying not to waste food. Well, I have solved all those problems thanks to Lomi, and it's changed the way I think about my food waste. Goodbye leaky trash bags running a line of drip liquid down my driveway, and hello Lomi. Lomi transforms my trash into treasure at the push of a button. Lomi is a countertop electric composter that turns food scraps to plant food in 4 hours. There's no food rotting in my garbage and smelling up the kitchen. Now I only take the trash out on garbage day and no more leaky bags. I turn my waste into nutrient-rich Lomi earth that I can feed to my plants, lawn, or garden instead of sending it to the landfill. That lets me help the environment and makes my life easier. All my food scraps, plant clippings, and even those leftovers I forgot in the back of the fridge, they can all go back into my garden, helping me grow more nutritious food at home. And now Lomi's new app lets me track my environmental impact, earn points for every cycle, and redeem for freebies from Lomi and other great brands. I learned that food waste makes up a huge portion of our personal carbon footprint. By reducing the amount of food I send to landfill, I'm helping do my part for the planet. So now I get to eat well and clean up my garbage even better. Whether you want to start making a positive environmental environmental impact, or just grow a beautiful garden, Lomi is perfect for you. Head to lomi.com/LegalAF and use the promo code LegalAF to get $50 off your Lomi. That's $50 off when you head to LOMI.com/LegalAF and use promo code LegalAF at checkout. Thank you, Lomi, for sponsoring this.
Oh, hey, I didn't see you there. Look, everyone knows how annoying cheap razors are. The cuts, the irritation, the frustration. And don't get me started with subscription razor services, the headaches that those can cause. That's why you gotta meet Henson Shaving. Henson Shaving is a family-owned aerospace parts manufacturer that has made parts for the ISS. That's the International Space Station and Mars rover. And now they're bringing precision engineering to your shaving experience. Razor blades, they're like diving boards. The longer the board, the more wobble. The more wobble, the more nicks, cuts, and scrapes. A bad shave, it isn't a blade problem. It's an extension problem. By using aerospace-grade CNC machines, Henson makes metal razors that extend just 0.0013 inches, which is less than the thickness of human hair. That means a secure and stable blade with a vibration-free shave. It gets better. The razor has built-in channels to evacuate hair and cream, which makes clogging virtually impossible. Seriously, Henson Shaving wants the best razor, not the best razor business. That means no plastic, no subscriptions, no proprietary blades, and no planned obsolescence. The Henson razor works with standard dual-edge blades to give you that old-school shave with the benefits of new-school tech. Once you own a Henson razor, it's only about $3 to $5 per year to replace the blades. My first shave with the Henson razor was incredibly refreshing. The design is sleek and the durability is top-notch. The Henson razor is truly so much better than your run-of-the-mill quote-unquote traditional razor brand. And the affordability factor is absolutely game-changing. No more wasting your money on expensive blades. With Henson Shaving, you can get a year of blades for just $5. Okay, so this is what you have to do. It's time to say no to subscriptions and yes to a razor that'll last you a lifetime. Visit hensonshaving.com/LegalAF to pick up the razor for you and use our code LegalAF and you'll get 2 years worth of blades free with your razor. Just make sure to add them to your cart. That's 100 free blades when you head to hensonshaving.com/LegalAF and use code LegalAF. And now back to the video.
Welcome back to Legal AF. We are live, Ben Meiselas and Michael Popok. So we go from a fairly organized docket in the federal case in Washington, D.C. to kind of utter chaos in the docket in the Southern District of Florida in the case involving Donald Trump's willful retention of national defense information and other classified records and top secret records. He's also being charged with making false statements and obstruction of justice. He's got 2 co-defendants as well, Waltine Nauta and Carlos de Oliveira. That case in the Southern District of Florida, being prosecuted by Special Counsel Jack Smith, is before Judge Eileen Cannon. Remember how we were talking about SEPA Section 4 as it relates to Judge Tanya Chutkin and how Judge Chutkin is creating a very kind of expedited but very just normal way of handling SEPA Section 4 issues, and Donald Trump's lawyers, as a result, have to respond as lawyers do. They have to basically say, Judge, please, can we be a part of the SEPA Section 4 process? And they're making the appropriate, they're making the requests. They're acting inappropriately, but they're making requests to the judge. The judge can evaluate their requests and their conduct and ultimately make a determination on the merits based on evidence. But then you go to the Southern District of Florida before Judge Cannon. We reported how, again, it's a fairly straightforward case. And as you mentioned at the outset before Judge Cannon, did Trump steal the records? Were they national defense information? Right? It's kind of like that. And did he have the requisite intent? Did he have the requisite mens rea? Almost what the documents themselves say is kind of irrelevant, right? Because the issue is just, were they national defense information? Did he steal it? Did he obstruct justice? Did he make false statements? So actually, the content of the document itself in the DC case is probably more relevant than that in the Southern District of Florida case, even though the Southern District of Florida case involves classified information. But last week, Judge Cannon on her own, basically after, well, Trump requested it, but she didn't make a ruling. She basically said that for purposes of SEPA Section 4, rather than even like have a SEPA Section 4 hearing or even like deal with the documents, she like extended the SEPA Section 4 deadline indefinitely. There is no date. She just ordered that those dates be continued. And as she put it, temporarily stayed. So she stayed herself. Oftentimes we hear about like, the Court of Appeals or the Supreme Court issuing a stay. She issued a stay on herself, right? That was 2 weeks ago. And as we reported, you go back to the last weekend's LegalAF, we were like, okay, she's doing that so that she doesn't have to issue a final order on the issue that then Jack Smith can appeal. Because Jack Smith has to wait for there to be an order, and then he appeals an order. But when she like stays herself and delays the deadlines, trial's supposed to be set in May of 2024. She hasn't moved that date yet. She's doing enough to create confusion without issuing an order that Jack Smith can take the order that you can then go to the 11th Circuit Court of Appeals to get her reversed. And so she's, my view that I said last week, and I think Popok, you agreed, is that she seems to have been doing that on purpose to try to incrementally move the chains and or keep the chains where they are, if you will, and just cause delay. And so this week there was a big hearing over the potential conflicts of interest of the lawyers that Trump is paying for co-defendants. His co-defendants, Waltine Nauta, the valet, his co-defendant, Carlos de Oliveira, represented by lawyers named Stanley Woodward and John Irving, respectively. And those individuals also represented, keyword is represented, no longer represent, a bunch of witnesses who want to testify against their clients right now. So that creates a bunch of potential conflicts. And one of the grounds that a litigant can make after they're convicted to try to appeal their conviction is ineffective assistance of counsel. And ineffective assistance of counsel is a ground that cases get reversed on all the time under constitutional grounds in criminal cases, not really civil cases, but in criminal cases. My lawyer was ineffective. So to protect against that, lawyers, prosecutors hold what's called Garcia hearings, where there's conflicts of interests, where a conflict of interest could be used after a conviction by a criminal defendant to basically say, I didn't have effective assistance of counsel. So the question becomes, is the criminal defendant aware of potential conflicts of interest? Do they knowingly waive the conflicts of interest after knowing all of the potential issues regarding the conflict of interest? And is it even a waivable conflict of interest in the first place? There are some conflicts that our law and ethics of being a lawyer hold are so deeply rooted conflicts that they're unwaivable conflicts of interest, and a lawyer has to be disqualified. And what you do is you hold a hearing called a Garcia hearing. It's based on a seminal case involving someone named Garcia. That's why it's called a Garcia hearing. You ask the questions of the criminal defendant in an adversarial way. The prosecutors ask questions. Then the lawyers representing the criminal defendant can ask the questions to try to rehabilitate them or show that there's no conflict. And then the judge ultimately makes a decision, but there's a hearing. So with these lawyers right here who are representing Trump's co-defendants, you'd ask them questions like, one, hey, are you aware that Trump's political action committee is paying for your legal fees? And they may say no. Imagine if they said no, and they go, so you haven't been informed who's paying for your lawyers? And you could explore that avenue. Or maybe they say, yes, they are aware. Are you aware that that could potentially create a situation where, because they're getting paid by Donald Trump's political action committee, their loyalty may be split and they may be wanting to help Donald Trump? They can answer that question. Are you aware that you have the right to have a federal public defender? Are you aware that you don't have to be forced to be represented by those people? Are you aware that the government may be interested in entering into plea negotiations and discussions with you? Are you aware that your lawyers are also representing other witnesses who may have testimony against you? Are you okay with that? Are you aware that your lawyer may not be permitted to do certain portions of this case because there may be conflicts presenting that, and you may not have the full counsel, the full attention of your counsel to your case? Are you go through the questions, and then you determine, is this an unwaivable conflict that the lawyer should be disqualified? Should the lawyer just be walled off from certain portions of the case, like cross-examining a former client who's a witness, because obviously they may have learned client confidences in that situation? So can you wall off the lawyer from that portion of the case? Is there no conflict at all, and we could just go along with the case? But once a decision is made after the Garcia hearing, a ruling is issued by the judge. And if the ruling is the wrong ruling, that's where Jack Smith or whoever the prosecutor is can go to the 11th Circuit Court of Appeal. So that hearing was on Thursday. Carlos de Oliveira had his first hearing, and that went fine. But then it went to the next co-defendant, Waltine Nauta, and Judge Cannon was asking questions of the prosecutors, and the prosecutors were saying, well, one of the things we're going to ask for, Judge, potentially, is to bar Waltine Nauta's lawyer, Stanley Woodward is the name of the lawyer again, from potentially being in the case if that's where the evidence leads. We want a full bar, or bar him from being involved in certain portions of the case.
Which, by the way, Ben, came up in the earlier hearing with de Oliveira. One follows the other. That issue was addressed and easily dispatched by the judge with de Oliveira. And then it came up again with Nauta. Go ahead.
Well, because that's what a Garcia hearing is. So when Judge Cannon then got livid at the prosecutors, and she said, you're springing on this for the first time. I feel sandbagged right now, Jack Smith's team of lawyers. For the very first time, you're telling me that you want to potentially bar Stanley Woodward. What's the precedent? Cite me the case.
They had just discussed it 2 hours earlier in the deal. They made a decision, and both parties agreed in front of this same judge just 2 hours earlier that Irving would not be able to cross-examine or handle some part, and that the local counsel in Florida would instead handle that part. And that's fine. Everybody went to lunch. They came back. This judge looked like she had a lobotomy and had forgotten. And this is the exact same issue. We don't want Stan Woodward to cross-examine this particular witness. Let somebody else do it. And now the judge is throwing the temper tantrum that you're describing.
And the whole point of the Garcia hearing, right, Popok, is you go through the hearing. What if there wasn't a conflict at all? Or what if the conflict was egregious? Whatever the outcome is, you do the hearing, you go through the questions that I just shared, and other questions like that. And then you decide what the remedy is. She got angry at the remedy that was addressed earlier in the day before doing the hearing. So she yelled at the prosecutors and kicked everybody out of the courtroom, and then said, we're postponing this, and that she was just angry. And then that ended the hearing. That's very bizarre behavior. And I want to get your thoughts on it. Yeah. It's not appropriate judicial temperament at all. And, it's what we've come to expect of Judge Cannon. But it's like, even if you had a basis to be upset at the prosecutor, which you shouldn't here, go through the hearing, get the data, and then you could do whatever it is that you want afterwards.
Right. You don't take your gavel and go home, which is what she effectively did. Let me do it backwards. Let me go back to the first part that you started talking about, because it looks like the prosecutors have even narrowed the case even more in the Mar-a-Lago case, and I know I did a hot take on it, and Ben, I think you discussed it maybe with the other podcast that you do. So the government had to respond because, once again, for the third time, Donald Trump and his lawyers asked for a delay in the case. They didn't like it earlier. They asked the judge to set the trial of this matter after the election. Just to remind everybody, the government said, how about January? And the judge says, I'm going to do it in May. At the time, we were like, okay, she's gotten the memo that says this guy's got to be tried before voters go to the polls, not after. And we were okay with that. We were like, okay, it's a little bit later, and we can live with that. And then Judge Chutkan said, March, I'll take March. And things are falling into place. But ever since that moment, as you said at the top of the podcast, the defense has sensed that they have a friend in an Aileen Cannon. And they keep trying to use her as a bulwark against a Judge Chutkan and against the other cases. And they constantly run to her like she's mommy to get something that they want, which is a delay in another case. They know Judge Chutkan is an immovable object, but they don't have a rock on the other side. They have Judge Chutkan, who's like a beanbag chair. And so they keep running to her to ask her for something. Help us. And she, she doesn't come right out and say it, but she acts out in certain ways to just naturally, her natural instinct is to delay decision-making, delay briefing, delay, fundamental rulings that she needs to make to keep this case on track. And we know she's doing that because we see her 180% polar opposite in Judge Chutkan, a more seasoned and experienced judge who really isn't letting politics interfere or the Federalist Society interfere with her decision-making, and is making decisions quickly with briefing schedules that are quick and then ultimate decisions that are there and keep the case on track for her March date. So when the Jack Smith's team caught that in a reply brief submission, you did a nice hot take on this one, Donald Trump threw in another footnote request for a continuance. We can't try this case due process, and it's obvious that the prosecutors, hell or high water, even running roughshod over our due process rights, just want a trial before the election. To which, by the way, we say on this podcast, yes. The voters need to know whether they're voting for a convicted felon or not. It's that important. That's more important than a slight delay here or there. And I reminded people on my own hot take, there's 7 months from now until March. There's enough time to try 2 Mar-a-Lago cases. This is not a complicated case with a lot of moving parts at all. It's a handful of classified documents. There's 30 in number. Yes, there's a batch of National Defense Information documents, but even the Jack Smith team conceded that the heart of their case, the centerpiece of their case, is not even the National Defense Information to figure out what is or what isn't. It's the 30 classified documents. And I know that because they put it in their own filing, which they just filed 5 days ago. And they said as follows, and I quote from their brief, that the classified materials at issue in this case were taken from the White House and retained at Mar-a-Lago is not in dispute. What is in dispute is that it occurred, why it occurred, and what Trump knew and what Trump intended in retaining them, all issues the government will prove at trial with unclassified evidence. Whether the highly classified documents Trump retained at Mar-a-Lago contained NDI, National Defense Information, is a fact Trump can try to dispute, but it will hardly be the centerpiece of the trial. Centerpiece of the trial is the 30 classified documents. He's gotten 21 of them. There's 9 more to go, which he's complaining about, which is awaiting the construction of this facility and some other protocols to be set in place by a foot-dragging Judge Chutkan, and he'll get those with plenty of time left on the clock. Got 7 months. I've been in cases where the government handed me new information the day of for a witness that was on the stand. It happens in federal court. It happens all the time. So there is no appropriate thing here for delay. And then you have all of that. And then we're trying to explain, being practitioners and being in federal courthouses regularly, what we're observing with Judge Cannon. Now, I'm not here to say that I've never been on the receiving end of an annoyed, irritated judge or magistrate. And neither are you, Ben, or Karen. We have. They wake up on the wrong side of the bed. I used to have a judge who will remain nameless in New York who started every hearing, and not just mine, he starts every hearing with, I hate this case. This case has been here too long. I'd rather not. That's how he started every hearing. And I knew he liked me because we had other interactions. So it wasn't me, but that's how he started. Judge Beryl Howell tore into the lawyers for Twitter when she sensed that they were trying to bend over backwards for Elon Musk to protect Donald Trump. I mean, ripped into them right away. But you also knew her order was going to rip into them. Cannon, I don't get it. I get she's never held a Garcia hearing before. She's only had like 6 trials. Or 8 trials, and most of them were during COVID. And this issue, these complexities of these issues, she hasn't addressed. Neither now or when she was at assistant Department of Justice attorney, primarily on the appeal side. She never handled them there either. And you don't handle these things in drug cases, which is primarily what's coming through Southern District of Florida. Political corruption cases, espionage, and national defense information, trust me, is not in the Judicial Training Academy for any place, let alone in Southern Florida. So I get it. She doesn't really know, and her staff probably doesn't know how to prep her either. She can make some phone calls to the chief judge. That probably would help. But when you have a hearing earlier in the morning, where the very issue that is now pissing you off and you're throwing the book at the prosecutors for no reason comes up and gets easily resolved, okay, that guy's not going to cross-examine that former witness. We're going to use another lawyer. Good day. And I'm sure the prosecutors were looking at each other, like Tom Wyndham, who got the brunt of Judge Cannon's attacks or reprobation, probably sat at a break with his fellow. What happened there? It's the exact same thing we just did earlier with De Oliveira. What's the problem with Stan Woodward not cross-examining at the end of the day, if it's possible, Walt Nauta? We really don't get all of, or in this case, Yuscil Taveras, the IT director, who's now going to testify that he was in on the conspiracy to try to delete the server footage at the behest of Donald Trump. And he said the exact opposite of that when he was represented by Stan Woodward in front of the DC grand jury. So that I don't get why that issue triggered her so much. Now, I'm still a cockeyed optimist that despite their constant requests, that there's plenty of time left on the clock to try 2 Mar-a-Lago cases, and that we're not going to see any real movement from the trial date that's now scheduled in May, remembering that Judge Chutkan was like, I don't know what she's doing with her courtroom. I'm taking March. And they point to that too. Oh, there's an overlap, and they know it. Chris Keiss, he won't be able to do 2 trials at one time. They're back to back. I've been in back-to-back trials, by the way. And you just do it and you prepare. So we're going to have to, as we've always done, keep a very close eye and try to interpret what we're watching with Judge Cannon. But there's no other way to interpret it, which is an inexperienced judge who seems to be bending over backwards for the defense. And the defense knows it.
Inexperienced, I believe, corrupt, and lacking the judicial temperament to even intelligibly conceal, in my opinion, the corruption that's taking place and the lashing out. It's so obvious what's going on, and it's very just, it's embarrassing for our judicial system to have a judge like this. I'll leave it at that. Let's talk about what's going on in Fulton County, Georgia. Michael Popok, we're gearing up for trial in less than 10 days of Trump's co-defendants, Ken Chesebro and Sidney Powell. We see some of the strategy unfolding by Fulton County District Attorney Fani Willis, who was ready for this trial when they made their speedy trial demand under Georgia law, which basically meant the case had to go to trial before November 1st. And you can see the strategy unfolding, that Fani Willis knows exactly what Ken Chesebro and what Sidney Powell are going to try to do. Like, especially with Chesebro, it's brilliant because, Chesebro's this appellate lawyer who kind of went full MAGA and got radicalized, but all of the kind of defenses he's tried to assert, you can tell his lawyer is just going to be arguing. He just sent some memos. He sent some emails. He was asked to give some legal advice, and he provided it. And you may not like the advice, but he's sitting in his ivory tower just writing these emails. Well, if the email is a plan to overthrow our democracy and overthrow our government, I don't care if it's 16 emails, 1 email, a crime is a crime is a crime. But you notice this, Popok, that they're requesting, the Fulton County District Attorney's Office is requesting subpoenas from Ronna McDaniel, the head of the RNC, and also Alex Jones. I want you to talk about everything that's going on in Georgia, but I just wanted to hit the Alex Jones one at the top about Fulton County District Attorney Fani Willis's strategy, because Ken Chesebro was partying with Alex Jones the day before the insurrection. He was buddy-buddy with Alex Jones and Proud Boys and Oath Keepers and all these right-wing terrorist organizations. He was literally hanging out and partying with them. So she wants to call Alex Jones in and compel his testimony, show the videos of Chesebro like hanging out with Alex Jones, and immediately crush exactly what Chesebro's lawyer is going to try to present him as. Going to be in his nice little suit, and he's going to say, "Oh, look at him." Go, really? You were partying with Alex freaking Jones. So tell us what else is going on. Judge McAfee, a superstar as well.
Yeah, let's stay on Jones for a minute. They've got footage of Alex Jones with Chesebro on Jan 6th at the Capitol, with Chesebro wearing a MAGA hat and walking around. Now, there's no evidence that they were there or participated in the actual insurrection or the violent attack on the Capitol, but she's going to show that video as well, and that he's in bed with just the wrong kind of people. QAnon, election denier, Sandy Hook denier, defamer, Alex Jones. Alex Jones says he's going to fight it, but he's been subpoenaed, and the courts in his state will honor the subpoena for Georgia, and he'll be forced to testify and validate the footage, the video footage that you're talking about, which is going to shrink Ken Chesebro down to size and undermine all of his arguments, as you said, is that he's just some sort of leather patch tweed coat wearing, pipe smoking, legal scholar that, it just came down and typed up some memos. He's trying to suppress the evidence of those memos from even being shown. He wrote not one, not two, but 4 separate memos in which he encouraged the use of alternate electors. We call them the fake electors, whether there was an existing valid court case in Trump's favor or not. The memos sort of take a turn halfway through as they got more desperate, and his argument that they could be used got more desperate as he circulated it to Rudy Giuliani, Sidney Powell, and other lawyers to use. And those are the object of the crime. Those are the evidence of the crime, and he wants them suppressed, not because they were illegally obtained, which is normally the foundation for suppressing evidence or excluding it from trial. It's not because of that. It's because they are real and they were used. But he wants to argue that he was only providing legal advice, and they're somehow covered by some sort of privilege and some sort of justification in law. And Fani Willis said, first of all, you're probably participating in a crime fraud which strips any attorney-client privilege away from whoever you are sharing it with, whoever has that privilege, and that's likely to win. And that's the argument that Jack Smith used to strip the attorney-client privilege away the last time Donald Trump tried to assert it over a lawyer, which was Evan Corcoran, his lawyer for Mar-a-Lago. But she's also going to argue, which I think is a very good argument, and that's where the videotape and the Alex Jones thing comes in, that these aren't legal memos at all. These are political memos. And if you're doing, a lawyer can serve a lot of different roles. I've been inside of a company as a deputy general counsel, as a head of litigation. Sometimes I was the senior vice president, managing director doing business things. And I don't get in my client, in that case, the company doesn't get the benefit of a privilege when they talk to me when I'm wearing that hat. Sometimes I was the head of litigation, head of employment matters, and therefore that conversation was privileged and my email exchanges related to it. So lawyers can serve in different functions, and sometimes the privilege applies and obtains, and sometimes it doesn't. And she's arguing this is all political strategy. He just wants to overthrow the country and try to pull levers in the state electoral process and federal electoral process. This isn't just a lawyer. He's gone beyond that, and therefore he doesn't get the benefit of the privilege. So she's got a belt and suspenders way to go after Ken Chesebro. This is again desperation that we're watching with these two people who are going to be tried. And we keep saying it, but until the day that we're on live television commentating and doing analysis for the Midas Touch Network, it's hard to believe. We keep talking about it like we used to talk about one day Trump will be indicted, we promise. And then he is, and it changes the weather in the room. But Sidney Powell finally woke up and started filing her own motions, but they're laughable. I actually said on one of my hot takes, was this created by ChatGPT? This can't be real intelligence. This has to be artificial intelligence that wrote this. She's actually claiming she wants the judge to take judicial notice, effectively, that she was allowed to coordinate the break-in of the Coffee County election office, use several people to go in there and download illegally, break into the voting machines and download illegally the computer software data for confidential voter data, so she could take it off in a thumb drive and use it in lawsuits or in hearings or or otherwise. And she's saying she wants the judge to recognize that there are statutes in Georgia that dictate how an election office repairs, maintains, and keeps their equipment in good working order. Okay, Sydney, what does that have to do with your break-in? The fact that they have the right and the obligation, and then she miscites every I did it in a hot take. Every statute that she cited, she left off key language that both Fani Willis and Judge McAfee will zoom in on. We've already seen how he writes, the judge, and say, yeah, that's great, but you forgot the first sentence. You forgot that, and so that's going to fail. The statute about how to clean the machines doesn't give you a defense for criminal liability for breaking into them and taking the software with you. And so you got that going on. And then the judge has got a couple of loose ends. He's got a couple of motions out there by Ken Chesborough on the supremacy clause for the U.S. Constitution should give him a defense. None of this is going to work. And none of this is going to get them a jury instruction either. They are going to start picking a jury on the 20th of October. It's going to take them 2 or 3 weeks. It's much slower in the state process than it is the federal process. We've read in reporting in Atlanta that the judge is going to bring down 900 potential jurors. That's a lot. And then start bringing them in, I guess, as much as the room can hold, 20, 30 at a time until they get their 12 in the box. With the challenges that each side is allowed to have. It's going to take a while. I mean, we'll open up the show and we'll talk about, jury selection has started. Whatever's in the public record, we're gonna report on. But in terms of an opening statement, that's going to be a week or at least 2 weeks away. There's some juries in jury selection in Georgia that takes like months, but because of speedy trial, this might go much, much quicker. But I don't think we're going to see an opening statement until week 2, which would put us like right around Halloween in Georgia for that. Isn't that appropriate? Or mischief night?
You've got that going on in Georgia, and then related to Georgia, because Ruby Freeman, Shay Moss undoubtedly playing a important part for the prosecution in the criminal case against the RICO conspiracy for all the threats that they endured. There's a civil component of the defamation and threats they experienced taking place in Washington, D.C. before federal judge Beryl Howell, where Ruby Freeman and Shay Moss filed a defamation case against Rudy Giuliani. The court's already found Rudy Giuliani liable based on the fact that he's engaged in all of these discovery abuses over and over and over again. So already found liable, but it went from horribly bad to even worse, if you can imagine, because Giuliani's been trying to hide all of his financial conditions from the most basic discovery over, like, produce your bank records, produce financial statements, produce all of these things. And he refuses to do that. So finally, Judge Beryl Howell warned him first before this, like, hey, I'm going to issue an instruction against you to tell the jury, if you don't turn over the financial records you're supposed to, the jury can infer, for all they care, that you're hiding tens of millions of dollars when they assess damages and punitive damages against you. So let the jury decide that you're hiding massive amounts of money because you're not participating in the, in discovery over financial condition, which is, again, one of the ways you compute the multiple for punitive damages as well. So Popok, Giuliani, again, acting like he's above the law, doesn't produce the most basic records. So you had Judge Beryl Howell take action and take authoritative action. And she issued a ruling that has a devastating adverse inference against Giuliani. Popok, go through this with us. But Giuliani's, I would not be shocked if Giuliani on the low end gets hit for like $10 million.
Oh, yeah.
On the high end, I think it'll be close to $1 billion and then maybe have to be reduced.
Right.
They may hit him with he won't be able to, he's not going to be able to pay $1 billion. If it's anything over $10 million, he's going to be totally bankrupt. But this is non-dischargeable in bankruptcy as well because it's intentional. Giuliani, from a financial standpoint, he's over. He's ruined. And then what it's going to come to is a constant collections game over getting the money from him and chasing him for the rest of his life.
Yeah, agreed. I said in a hot take that'll be posted soon that the judge has brought down the hammer and the curtain on Rudy Giuliani. From the best we can see from his assets that are out there, he owns a property in Manhattan and he owns a property in Florida. One has a tax lien on it. He probably has net that he can, if he sold all of his assets, putting aside his common sense, whatever that show's called on his podcast and whatever he can generate from there, he's got maybe $7 or $8 million, which sounds like a lot, but it's not a lot when you're facing legal fees that'll be drained for the 13 count indictment in Georgia, all the other defenses he's had to do, and now the case and the ultimate judgment in this case, which will be well in excess. I agree with you with $10 million. If E. Jean Carroll out of a New York jury got $5 million in punitive damages, including for a rape and defamation, the defamation here, given the instruction that the judge, as a punishment for Rudy Giuliani's bad behavior, is going to give to that jury, a jury whose sole function, having been told already by the judge that liability, defamation, intentional infliction of emotional distress, conspiracy, and punitive damages have already been determined by the court before you even sat down in your chair. Your sole purpose, ladies and gentlemen of the jury, is to decide how big an amount to award Ruby Freeman and Shay for the defamation, intentional infliction that they suffered, and punitive damages to pay back and to punish the defendant in an amount enough that he actually feels it. That's your job here today, or find that there's no damage, which of course they're never going to find. And the judge warned Rudy Giuliani. Just a moment here of a personal exception. I don't know what's going on with Rudy Giuliani. I don't know what's going on in that gray matter of his. He defaulted and stopped participating in New York at the moment he was about to lose his law license, and lost his law license in large part, not only because he did bad things, but because he defaulted. He stopped participating in the process, and he did it all over again down in with Judge Beryl Howell, who among all federal judges, Beryl Howell doesn't play. Beryl Howell was the chief judge who presided over every one of the grand juries Jack Smith has used in Mar-a-Lago at the beginning and the Jan 6 case, in an election interference case, related to all things. Because she was the chief judge at the time for a year and a half, she presided over and heard all the evidence. She made all of the decisions about all the bad people in Trump's world. She stripped Evan Corcoran of the attorney-client privilege, finding that it was more likely than not that Donald Trump and Evan Corcoran committed a crime or a fraud. She knows Jan 6th and everything related to the cling to power better than anybody, better even than Judge Chutkan. And yet, and because judges in the federal court hear civil cases and criminal cases, and when they're the chief judge, grand jury matters, she got the short straw, or Giuliani did, to get her assigned to his case. Ruby Freeman and Shay Moss are two tremendously authentic, compelling victims here of Donald Trump's cling to power. Ruby Freeman was mentioned 18 times by Donald Trump in his call, the perfect phone call to Brad Raffensperger to try to steal the election, the Secretary of State of Georgia. Giuliani incessantly banged these two people and caused Donald Trump's supporters to dox them, cause them to do violent rhetoric, racist rhetoric, attack them. They had to move out of their houses and get police protection. They're also involved in Georgia because at least 3 of the defendants in the Georgia case, some sort of pastor, Willie Floyd III, who was the head of Black Voices for Trump, and Trevion Cutie, who was a stylist for Kanye West, went to Ruby Freeman to try to get her to admit that she committed a fraud in the electoral tally that she didn't commit, and pressured her to do it. That's why they've been charged over there. So Ruby Freeman is unfortunately, she didn't ask for this. All she wanted to do was to be an election worker, counting election votes for low or no money with her daughter. Okay, or the other way around. She's the mother, and the daughter is Shay Moss. But enough is enough, and they sued another right-wing media company that already settled with them, and Rudy Giuliani. Rudy Giuliani has defaulted on every obligation that he's had. He's violated and flouted every order of this judge. That's how he got the sanction against him, that he has no defenses, and she found liability against him without a trial as a sanction. She, in the order that she just issued, which I've never seen in 32 years of practice, an order like this, she said, this is on top of page 2, consistent with his prior track record in this matter. By the way, note to our followers and listeners and watchers, when a judge refers to a track record, it's never a good thing. It's never like Secretariat just won the Triple Crown. No, it's she did a really bad series of things, that judge is commenting on it. Giuliani failed to file any response to plaintiff submissions, despite being permitted to do so by her order in September. And he did the same thing in October. The judge said, when she ruled against him and said, as a sanction for your misconduct, you don't have a trial on liability. I am finding you liable for defamation, infliction of emotional distress, conspiracy, and even punitive damages. Now you'll only have a trial on liability. And that's not all. If you screw up again and don't provide by this deadline, and she gave him a deadline, all of your financial information about your podcast, its revenue, all of your businesses, their revenue, how many times you mentioned Shay Moss and Ruby Freeman, ad rates for those shows. You don't give that all over so people can calculate punitive damages and whatever. I'm telling you now, I am going to instruct the jury that they should infer, meaning they have to assume that you're hiding your financial information in order to lower the potential judgment. And if you want to play that game, go try it. Now, you'd think at least that would be the wake-up call for Rudy Giuliani. Okay, well, I don't want that to happen. And he violated the order again and missed the deadline. Or as the judge put so eloquently at the top of page 4, given that defendant Giuliani has failed to comply with any part of the August 30th order or file any opposition or objection to plaintiff's submission and proposed adverse instructions, that's it. You're done. And here's the instructions. This is what the jury is going to be told in the first hour after they're selected, after they're told this case is only about the amount of damages, and Rudy Giuliani and these two. The jury will be instructed that it must, when determining an appropriate sum of compensatory, presumed, and punitive damages, infer, meaning assume, that defendant Giuliani was intentionally trying to hide relevant discovery about his business's finances for the purpose of shielding his assets from discovery and artificially deflating his net worth. Ladies and gentlemen of the jury. 2, you are instructed that you must infer that defendant Giuliani was intentionally trying to hide relevant discovery about the viewership of the Common Sense podcast and his social media reach for the purpose of artificially deflating the reach of his defamatory statements. 3, the jury will be instructed that it must infer that defendant Giuliani received substantial financial benefits from the defamation of the plaintiffs. They have to assume that. And 4, the jury will be instructed that it must infer that the Giuliani businesses continue to generate advertising revenue and other income from their operations. But it goes beyond that. Now she bounds and gags and ties one hand behind Rudy Giuliani's back because of his own misconduct by also barring his lawyers or him from making any arguments in front of the jury as follows. 1, defendant Giuliani will be precluded from introducing any evidence through any source, document, witness, testimony that has not been already disclosed in discovery. And he disclosed very little in discovery, so he's not going to be able to rely on anything else. 2, he'll be precluded along with his counsel from making any argument or introducing any evidence or stating or suggesting that he received no financial benefits or immaterial or insubstantial financial benefits from the statements he made against the plaintiffs. And lastly, they will both be precluded from making any argument or introducing any evidence that Giuliani is insolvent, bankrupt, judgment-proof, or otherwise unable to defend himself, comply with the court's orders, or satisfy a judgment. Rudy just needs to sit there, let the evidence be presented by the plaintiffs, and let the jury pull out his checkbook and write a giant check. The only thing the judge gave Rudy Giuliani, and it's not even, talk about ice in winter, is that he's also failed to pay over $235,000 in attorney's fees in sanctions along the way in 3 separate orders. And so the lawyers said, look, this guy seems to be doing everything he can to avoid paying a judgment. Can you give us a judgment for the $235,000 right now so we can at least go try to garnish his wages, get a sheriff to go seize property, put a lien on the 2 pieces of real estate that have already been identified in the press? And the judge said, why don't we wait 2 months for the trial, and then I'll give you one big fat judgment that you can use against Rudy Giuliani that includes in it $235,000 running with interest and whatever the jury awards. And then you can go take that and go try to chase Mr. Giuliani. But I don't see anything in the law that allows me to give you an early judgment on attorney's fees only. So that's the only thing Rudy got. And I'm not even sure, Rudy, who do you think is going to represent Rudy at trial? Nobody wants to represent him, and he owes every lawyer in town.
Exactly. I don't know who, but it will probably be another MAGA make attorney, get attorney representing him, which proves the make attorney, get attorney adage that we've coined here at the Midas Touch Network and on LegalAF. Look, here's the important thing to note about Rudy Giuliani also. Judge Beryl Howell didn't just wake up one day and go, I don't like you, Rudy Giuliani, and therefore sanctions, adverse inference. It's why we have this show, LegalAF, and do the work that other media networks don't do, refuse to do. It is important that, yes, on the Midas Touch Network, are we going to cover the shiny objects here and there? Yes, we're going to cover it in detail, but it is critical that we stick with stories and we go through in painstaking detail all of the intricacies of these cases, all of the evidence that's being presented. We provide point, counterpoint, and then we could all reach conclusions together. And our opinions may wind up being the same. Our opinions may wind up being different. All of that is fine, but ultimately we have to follow the evidence. And Judge Beryl Howell gave Giuliani not one chance, not two chances, dozens, close to 50 opportunities. And you know, by watching this show, we've covered all of those times where, hey, Rudy, can you please submit that, response in opposition? Rudy, can you do this? Rudy, can you do that? And what did he do each and every time? Disobeyed the order. And then he would agree to an order, and then he would try to wiggle out of it. And then enough's enough. And the judge went through the process. I'm sure it took far longer than anybody would have liked. And people were going to say, well, when's justice going to be here? When is there going to be accountability? And I'm sure it's the same questions you're asking about with the Donald Trump cases as he tries to do all of these maneuvers. But look, when you have good lawyers, when you have good prosecutors, when you have law and order judges, yes. Can wealthy, powerful people take advantage of our system? Yes. Are there times where they get away with things? Yes. But ultimately, do I feel confident that while our system of justice is not perfect and has lots of problems, it's one of the best out there? I do feel that way. And the wheels of justice turn in the right direction. And we're going to be there with you each step of the way. So if you want to help support this independent media network, check out patreon.com/MidasTouch as well. patreon.com/MidasTouch. We don't have outside investors here on the Midas Touch Network or LegalAF. So one way to support the growth of this platform is by going to patreon.com/MEIDAS TOUCH. Go there now. Check that out. Become a member if you can. Check through the archive. We have the origin story of Michael Popok, of Karen Freeman Agnifilo, of me, and of others. I think you'll love the exclusive content there, and you'll help grow this platform. The best way you can help, though, also is just subscribe to our YouTube channel, subscribe to our audio podcast, search LegalAF, share this with friends, family, coworkers, neighbors, whoever. That's a great way you can help. Leave a 5-star review on audio, and you can check out the LegalAF gear at store.MeidasTouch.com as well. Store.MeidasTouch.com as well. Thank you all so much for watching. We look forward to seeing you next time on LegalAF. Shout out to the Meidas Mighty.